Hello, everyone. Welcome to today's webinar, Help, I'm a Victim of Online Harassment. I'm Holly, your moderator for today. This webinar is part of the Law Awareness Weeks at CDC2021. It is a collaboration between the Law Society Pro Bono Services and the 5 community development councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, and the Singapore Corporate Counsel Association Pro Bono chapter, and is supported by the People's Association. Please feel free to ask questions at any time using the Q&A box in Zoom. It should be top or bottom of your screen. We will do our best to address your questions during or at the end of the talk. There will be a QR code featured throughout the slides. Please scan it for webinar handouts. A link will also be sent to you in the follow-up email that you should receive tomorrow. Please note that the discussion and any material provided in this webinar is not intended to substitute or constitute as professional legal advice. You should consult a lawyer if you require specific legal advice. So now I would like to introduce our speakers for today, Ms. Viviene Sandhu and Mr. Kenneth Ng. Viviene is a partner at Clifford Law LLP. She is an experienced lawyer of 23 years and has represented and defended clients in all manners of disputes, particularly family law, employment law, personal law, and civil disputes. As well as being a litigator, Viviene is an accredited mediator and arbitrator. In 2018, Viviene was awarded the State Court's Outstanding Volunteer of the Year Award in the Advocate and Solicitor category. Viviene's aim is to help simplify legal processes and ensure that everyone receives good quality legal advice. Viviene is happily married with 3 teenagers. She enjoys being a lawyer and helping others where she can. Kenneth is a young lawyer in his 2nd year of disputes practice and regularly acts for both individuals and companies in commercial and private disputes. He has also appeared before the courts in several harassment-related matters. He believes in giving back to the community and has been a keen volunteer in various legal and non-legal platforms since his time as a student in the National University of Singapore Faculty of Law. So thank you to Viviene and Kenneth for joining us today. I'm here today in my capacity as a co-founder of Solid Ground. Solidground.sg is a website created with my colleague, Catherine Chang, to provide practical information for people facing online abuse and harassment in Singapore. So with that, the aim of this webinar is to demystify the legal actions that are available for people facing online harassment. To give an overview, online harassment covers a wide range of experiences, including receiving any type of unwanted contact, or having lies or insults posted about you online, or having your private information or images posted to cause you harm. We'll go through 2 example scenarios that hit some of these topics and discuss the legal options available, including things like police reports, magistrates' complaints, protection orders, and mediation. So again, please feel free to ask questions at any time using the Q&A box. So let's go to our first scenario, jump right in. And do note that these scenarios that we'll explain can happen to people of any gender, so we refer to all of the individuals involved using they. Okay, so as you can see here, Avery is a freelancer who communicates periodically with a regular client. After a while, this client starts repeatedly messaging Avery, asking them what they're up to, whether they can meet up, and intrusive questions about Avery's personal life. Avery wasn't comfortable with this and ignored the client's messages, but this only caused the client to message Avery more. They would also comment on every single post that Avery made on social media. Avery was reluctant to block or confront this person as they are a client, but the repeated messaging is causing Avery to feel like they are being monitored and to fear for their safety. So what can Avery do? So let's start off with Viviene. Maybe you can share how you would start advising a client who came to you with this kind of case.
Good morning, Holly. Thank you. Practically speaking, since Avery knows who the perpetrator in this case, but is worried about damaging his relationship, he should really, in my view, sum up the courage and tell the client to ease off, right? I call this a warning shot. And sometimes it works, sometimes it doesn't. If it doesn't, maybe he can speak to the perpetrator, the client, to a friend. If it doesn't work, then he should reconsider his decision not to block the client's social media accounts. most social media platforms these days also have reporting tools, which Avery can very easily use. Of course, more serious options, if the warning shot does not work, is to lodge a police report. And Avery can also explore other legal options like getting a personal protection order against a client. And he doesn't have to choose between these options. He can actually do both at the same time.
Okay, so then in terms of making a police report, how long does this whole process of investigations and charging in court usually take?
That's a good but tough question, Holly. It really depends on a fact-to-fact basis, case-to-case basis. And really, the important factors that the police look into are the seriousness of the offense, things that the client has done. The harm caused is a very big factor. And if the perpetrator is known, the process will be faster. So if Avery could present all the evidence to the police, it would certainly help them and expedite the process for their investigation.
I see. So then in terms of immediate relief, you already mentioned protection orders. So maybe Kenneth, I know this is an area you have kind of more experience. Could you tell us a bit about this option of protection orders?
Yeah, certainly. Thank you, Holly. So like Vivienne has mentioned, a protection order could be another option. And Avery can actually explore this legal option in parallel with making any police reports. So I think as some members of the audience might be aware of, a protection order, it actually comes under the Protection from Harassment Act, or POHA for short. And I think we'll be referring back to this piece of legislation quite a few times in the remaining sections of this webinar. So a POHA protection order is an order against a harasser to stop harassing or stalking that victim and to remove any kind of publication which causes harassment to the victim, in this case, Avery. So simply put, they're basically orders from the court directing a person to stop certain specified acts. And if you are the applicant for a protection order, you can actually specify what acts you want inserted in that order. And Holly, as you mentioned, if Avery wants immediate relief, depending on how serious the harassment is, the court can actually grant an expedited protection order. So this is sort of a special subspecies of an ordinary protection order. It's called an expedited protection order, or EPO for short. And it's basically for situations where there is an extremely urgent need for the harassment to be stopped or prevented from happening. Typically, the court will endeavor or ideally will try to grant such an urgent order within a few days of an application being filed.
So that's good to know. And you mentioned that it can include specific things. So for instance, in Avery's case, it could say, stop messaging this individual, stop. Could it include things like, stop commenting on their social media or posting about them, things like that?
Yes, certainly.
Okay.
So I think ultimately the terms of the order depends on what you ask the court to put in. And it also depends on what the judge decides to put in. But certainly in a situation where the harassment is coming through very specific channels, like you mentioned, comments on a certain page and things like that, that can be inserted as well, either specifically or generally into the wording and the terms of the order.
Okay, good to know. So then let's go back a little bit to the kind of criminal path of, say starting by making a police report. So Vivienne, can you just go through kind of the basics of how Avery could make a police report and then sort of what happens after you start that process?
Yes, okay. Police reports, very simple. You can file a police report online in this day and age, or you can just go to a nearby police post. So the police will then look into the details of the case, what the facts are, and then decide whether they want to investigate or not. If they decide to investigate, they will assign what is known as an investigating officer, or IO, to the case. And as part of the investigation, they will call the client. So the client will usually, at this point of time, they will just a phone call from the police will scare the living daylights out of the client, right? Can you imagine you get a call from the police? So the client will know the seriousness of the matter. And after the investigation officer completes his investigation, depending on the facts of the case, depending on what has happened, he will make recommendations to the Attorney General's chambers. They will decide whether they want to press charges against the client, and they retain the ultimate discretion whether to do so. But if the police, for whatever reason, decide not to investigate Avery's case, they might advise Avery to file what is known as a magistrate's complaint.
Vivienne, could I just check? And I think that this might be a burning question that some members of the audience have as well. What actually influences whether the police decide to investigate in your experience?
It really depends on the seriousness of what has happened. And in law, we call it whether it's arrestable or non-arrestable offense. If it's an arrestable offense, they are already legally obligated to investigate the case according to the Criminal Procedure Code, which states that the police must investigate if it's a arrestable offense. But for non-arrestable offenses, this is where the tricky part lies, right? The default rule is that if an offense is punishable by less than 3 years, then it's a non-arrestable offense. So for instance, many of the harassment-related offenses that we see under POHA are non-arrestable. So for these non-arrestable offenses, it is up to the police whether to investigate or not, and they decide on a fact-to-fact basis, very fact-sensitive. Is what I've alluded to. It really also depends on the harm. For every case, based on the facts, what we've shared is, I think they may not investigate. In which case, I think my personal view is Avery should file a magistrate's complaint.
Okay, so yeah, then maybe can you tell us a bit more about what what a magistrate's complaint is? I think, it's a bit less familiar.
Yeah, certainly. So essentially, a magistrate's complaint is an application, is a complaint, is an application which we file to court. The judge who hears it is known as a magistrate. So it's a magistrate's complaint. And you're asking the magistrate or the court to examine an offense and to give directions for further action, for the court to direct the police, for example, to investigate the case. It is only, however, possible for certain type of offenses. And it's quite technical here. So if there are any audience members who would like to learn more about magistrate's complaint or who are considering filing one, the courts actually have, the court's website is quite excellent, very simplified, easy. They've created an online pre-filing assessment so you can see whether your case actually qualifies for a magistrate's complaint. And I believe we'll link up all the resources provided at the end of the webinar. If the case qualifies for magistrate's complaint, Avery can apply then for one, start to apply for one online after the pre-filing assessment. And he will then be asked to go down physically to the state courts because he must swear the accuracy and the truth of the matter stated in the online application and pay a filing fee. Afterwards, the magistrates, if satisfied that all the documentation, for legal matters, you need to get your documents in order. The magistrates may do a couple of things. He may dismiss the complaint or direct the police, like I said earlier, to investigate. This usually is if the complaint involves serious allegations or offenses, or the magistrates may even move the case to private prosecution by issuing a private summons against to Avery's client, private summons to Avery's client to attend court. And what we see these days, more likely than not, is that the magistrate will order Avery and the client to attend what is known as criminal mediation.
So just to kind of make sure I understand, what you've just explained, a magistrate's complaint is still in sort of the criminal side of things as compared to a civil remedy, but it's you privately wanting to take this up rather than kind of the route where the police might pass it to the AGC. Is that correct?
Yes, it's known as also private prosecution.
Okay, because you're taking it on as a private individual.
Yes, because the police don't want to take it up, or for whatever reason.
Okay, good to know.
But it's not a clear-cut case.
Yeah.
Yeah. Vivian, you actually mentioned the last option, or the last situation you mentioned, that the magistrate could order Avery and the clients to attend criminal mediation. Could you share with us a little bit more about what criminal mediation entails?
Okay, criminal mediation is essentially mediation that is carried out between the complainant, Avery, and the respondent, his client, in a criminal matter. So it's essentially mediation in a criminal context. And mediation is a process where parties discuss their disputes with the assistance of a trained, impartial third person who assists them in hopefully reaching an amicable settlement in the case.
So then I've just seen a question from the audience while we're on the topic of magistrates' complaints. There's asking, and how much does it cost to file one? And then maybe I'll just add on, and as you kind of go through this process with things like mediation that might be involved, are there additional costs beyond the filing?
All right, I'll take this question. There's only a filing fee of $20, and that's a filing fee. You can actually do everything yourself online. And most clients actually can file this online themselves together with the supporting documents. And in most cases, the court will direct for the police to investigate or for the parties to go for mediation. So it's free unless you want to appoint a lawyer, in which you can appoint a private lawyer to help you through the process so that you feel more confident and more assured. So really, it's not expensive.
Okay, good to know. And then I just want to bring up, because a lot of what I'm interested in these processes is sort of the victim's experience of harassment, that, maybe in this case, Avery is kind of intimidated by this person, or basically doesn't want to see them face to face and kind of have additional contact with them. Is this necessary as a part of mediation?
Okay, good question. If the matter is sent for mediation, Avery must attend the mediation. Otherwise, it will be deemed that he's no longer interested in pursuing the magistrate's complaint, and the magistrates might even strike out the complaint. So, however, he can request in his court documents that he does not want to see the client. And the mediator, the court mediator will then likely accommodate. This is a very, very sensitive issue. So steps can be taken to try and make him feel safe and comfortable. But really, this is a really fact-sensitive issue.
I see, okay. And so then to kind of keep going through this process, what are the different types of outcomes that you can get from mediation? Do they just expect a simple, like, we've worked out something between ourselves, or what are the kind of outcomes, and then how is that structured, reaching them?
Okay, good question. But let me just go back to what I was talking about, where you have a client who, a complainant who doesn't want to see the client, the perpetrator, right? I just want to share that I had a case when my client, the victim, was 18, and he did not want to see the perpetrator. So the mediator in that case very artfully arranged for a private session, what we call the mediation process, a private caucus, right at the beginning, just between him and himself and each party separately. So as the mediator conveyed each party's positions and built bridges, the client felt less afraid and was more prepared to face the perpetrator. In another case I had, the perpetrator was quite young, 16, and his mother, who attended with him, had no idea that the perpetrator was, that her son, also her son, this happened to be a boy, also around that age group, was doxing my client. And she was crying the whole time. And my client was actually very happy at the end of the day to be able to put a face to this person who had been doxing him. And he only had his name. So when you file your magistrate's complaint, make it known what your harm is, what you've been facing, make it known that you do not want to see the perpetrator, and the mediation process can accommodate. And you might change your mind, or you might not, but it is a good way to resolve the problem. So you were asking me about the you were asking me
the possible outcomes. Yeah.
Okay, so what I've seen so far, and the great thing about mediation is you can be creative. What I've seen so far is compensation, talking about monetary compensation. In one case, I handled, they asked for legal costs because one party had lawyers and one didn't, and they felt that they had the right to get a reimbursement for the legal costs, as it were. Other people get monetary compensation for donation. Then there's undertakings. You can promise not to do it again. Promise not to post anything on any social media platform. You can keep the wordings wide because just now Kenneth was talking about the terms. Of course, it's removal of the post quite clearly, and a video apology, for example, to say, you're sorry, record yourself, and then send it to the victim so the victim can keep it, or the victim might want to post it. This is hard to get the video apology, but can be done. I just want to share here that I had a case where the video apology was sought, and the perpetrator agreed, but he was quite cheeky. He wore his mask, so you couldn't really see his face in the video apology. So we had to call everybody back in the end and just, look, if you want to make a proper video apology, you make it on your own. You're obviously using your phone, so remove your mask and make a proper apology because this is not acceptable. Yeah. So we can be creative in mediation. Usually it's video apology, removal of the post, undertakings, compensation, and the like.
Okay, thank you. Yeah, so I kind of want to go back to protection orders specifically, and then I'll add in, we have some questions from the audience about protection orders since we mentioned them already. But maybe Kenneth, you can first kind of explain, just the process of getting a protection order if, say, in this case, Avery felt like they wanted to get one.
Sure, certainly. So, I mean, going through the route of applying for and obtaining protection orders is actually a separate route from the magistrate's complaint that Vivienne has been speaking about. So if you want to go under the protection order route instead, that's actually under the POHA, like I mentioned a few minutes ago. And the process for that is actually quite simple. It's been simplified quite recently. So applicants who want to file a claim for protection order, they can basically go to the online filing system on the state court's website. It's called the CJTS for short, or the Community Justice and Tribunals System. But if you Google state courts CJTS, it should be quite simple and quite easy to find that. So once you enter that website, it's quite self-explanatory. There will be a form for you to fill up on the website, which can guide you through the process. And you will need to have your particulars and your supporting documents, for example, on hand. But once you file the application online, the courts will be able to guide you through the next steps and the hearing dates for your application as well.
Can I jump in and ask you what you mean by supporting documents? What kind of things would that be?
Sure. So your supporting documents would be the documents showing the judge basically why you require this protection order to protect you from harassment. So I think off the top of my head, a few examples would be if strangers are texting you or harassing you virtually online. Basically, it would be screenshots of these messages coming in. And it would be useful also to have screenshots of the users who are sending these messages. If you know the identity of these harassers, that would be useful to have as well. Basically, what you want to do is to try and collect and put together and compile as much evidence as will be useful for you to show the judge that, look, there's a clear and urgent need for me to be protected, because this has been happening to me for the past 2 weeks or 2 months or 2 days or 3 days, for example. So it's basically a depository of sorts of documents where the judge can look at and objectively say that, okay, yes, I think there's a need to grant this order and protect this individual.
Then can I ask, since you mentioned sort of this thing about the time period, we have one question from the audience that's about, is there a statute of limitations for harassment cases? So could you say, yeah, this happened maybe, I don't know, a few months ago or last year, but if you have it, say, documented in screenshots, could you still apply for one?
So to my knowledge, there is no statutory limitation period for harassment cases. Although the exact timing of when the harassment happened, it could basically, it's a little bit technical because the Harassment Act was recently amended and then there were new rules that were enacted. So the exact timing of when the harassment happened could affect whether you go under the old process or the new process. But basically, whenever harassment claims or actions for protection orders are brought, it's usually for more recent cases. So I think the members of the public don't have to be too caught up with that, but it will probably fall under the new process. But actually, I have a separate point that came to mind, that there is no limitation period to my knowledge, as you mentioned, Holly. But how this might be relevant, the time frame which has elapsed, is that sometimes the courts hearing protection order applications, they want to be satisfied that there is an urgency or there is a need for the application to be granted. And in determining that, they will actually look at when the last harassing acts happened. So if it happened a few days ago or a few weeks ago, for example, or of course, if it's a continuing set of acts that's still happening, the court would generally be more minded to find that, yes, there is some urgency. But if the harassment happened, for instance, 1 year ago or 2 years ago, and there haven't been any more instances of the harassing acts, then the court might actually think instead that, well, I mean, with the inflection of time, there hasn't been any new instances of harassment that you've suffered. So unfortunately, there isn't really a need for that protection order to be granted, unless you have evidence of the harassing acts continuing and happening in pretty recent history. But of course, it's not a black and white situation. It all depends on the facts. Yeah, and that is what you would have to put before the court.
I see. So let me just see if my understanding is correct, because under POHA, there are both civil and criminal options available, correct? So you're saying essentially there's no statute of limitations for a case to proceed, but in terms of the civil remedy of getting a protection order, since that's designed to just intervene and prevent further harassment, that has kind of this built-in logic that there needs to be a kind of obvious imminent risk of the harassment continuing. Is that correct?
Yeah, that is correct.
Okay.
Yeah.
Okay, great. So then let's see. Someone else has asked, I think, to kind of review the difference between the protection order versus the expedited protection order. So maybe you could just talk a bit more about that, especially kind of as it pertains to what the process might look like for one or the other.
Sure. So I think simply put, both orders are quite similar. the terms, the substantive terms of the orders, and what the respondent of the application is prohibited from doing, those would be quite similar across both types of orders. The PO, let's call it a PO for short, protection order, the PO, and the expedited protection order, the EPO. So the key difference between a PO and an EPO is that a PO is supposed to act as a final order. That's what comes at the end of the application or at the final hearing. When the judge is satisfied, for example, that you need to be protected through that order. On the other hand, EPOs, expedited protection orders, they are not final, but they function as interim protective relief. And why we call it interim protective relief is because it's basically, that order will basically be enforced while the rest of the application is pending. So for example, if the main application for protection order, if it takes, let's say 2 to 3 months in your situation, in certain cases, for it to be fully resolved by the court, what happens is that in the interim period, you can, when you're filing your initial application for a protection order, you can also indicate to the court that, hey, I need something to protect me urgently in the interim period. I can't wait for 2 or 3 months because there's all this harm that's already happening. And you would have to provide your evidence, of course. And you basically tell the court, can I have an, you basically apply for this EPO first. And what the courts will do is, because the respondent won't be present at this hearing for the expedited protection order, it's something, it's what lawyers call an ex parte hearing, where only one side is present. So the judge will basically decide whether there's an urgent need to grant that expedited protection order. And the courts will actually, they actually aim to grant you a EPO hearing within 2 to 3 days of your application being filed. Yeah. So, okay, I mean, to keep it very short and simple, most of the time, if the harassment is extremely serious and there's an urgent need to protect the victim, applications for protection orders would include applications for expedited protection orders as well. And the EPO will serve as an interim protective relief for you until the final hearing of the protection order application. And at the final hearing, if the protection order is granted, the EPO will be discharged, of course. And similarly, if you don't get your final protection order, the court won't have that EPO, that previous EPO, it won't hold it in abeyance for you indefinitely, and it will have to discharge that as well. But at least, you know, the applicants will have the security of mind and will be able to protect themselves, especially in cases of where there are threats to their physical safety. EPOs would be very helpful in the interim.
And then, yeah, an additional question from the audience is about how long a protection order lasts. And then maybe I'll just add an additional one because I think they would happen sort of at a similar time, which is about how a protection order is enforced. And generally, you know, what the victim could do if the perpetrator continues their behavior.
Sure. So, to my knowledge, there's no time limit for protection orders. There's nothing in the order that will say, okay, this order is only going to last for a period of 2 months. And then after that, you have to apply for another order.
So are they like indefinite?
Yes, they would be indefinite in that sense, as long as the persons who are the subject of the order, the applicants and respondents, yeah, it would be indefinite in that sense. It's very, I've never, in my experience, I've never come across any protection orders that are limited by any time periods. Yeah. And then for your second question on how are protection orders enforced, so that's a very relevant question actually, and a very important question. So for an order of court to be enforced, in general, not just protection orders, they have to be actually served on the respondent first. So you would have to basically deliver that order to the protection order to the respondent. Usually in other areas of law, the rules on service can be quite rigid. The court may say you have to serve this personally on the respondent, meaning it has to be done physically. You can't just leave it at his residence or send it to him through email, for instance. You have to see him face to face, and then you have to hand that over document to him, basically how you see it in, I don't know, US legal dramas where they say you've been served. But for the POHA regime and for protection orders, the rules on service are slightly more flexible. I think you can basically do it through all the normal avenues, of course, face-to-face and so on. But the court actually has the discretion as well to grant much more flexible forms of service and to allow that to be valid service under the law. So for example, the court can actually allow you to send it through email, to serve it through social media messaging, for example, through Instagram direct message, for example, or Facebook messaging, or by posting on as a comment on that person's social media profile, and so on.
I see.
Yeah.
So then once you've served it, if that person continues, say, posting or messaging you, do you have to take it kind of on yourselves in terms of the victim, or in this case, Avery has to go back to court, or how does that usually happen?
Sure, that's a great question. So service is actually the first step. Yeah, that's correct. And it's a separate second step from the actual enforcement of that order. So if the respondent, after being served with the protection order, he, she, or they don't play ball, then you will need to apply to the court to actually enforce it. And this is the part where it gets slightly trickier. I know I've mentioned earlier that applicants can file protection order applications by themselves on the online system. That's because it's that's actually the default position under the Act. Applicants have to file their claims in person and represent themselves. But when it comes to enforcement, I mean, assuming the court grants you a protection order and you serve it, but the respondent is still continuing their harassing acts, at that point, then you will need to engage a lawyer to actually help you enforce that order. And that entails applying to the court, of course.
But then, so what do you mean by enforce? Does this process then involve the police, or what is the means through which you get this person to stop their actions?
Sure. It doesn't exactly involve the police, but basically there are certain court processes which allow the court to make a finding of contempt. For example, if someone who is supposed to comply with a court order doesn't follow through. So basically, if that person doesn't comply with the court order, what lawyers would do to ensure that the order is enforced is they would basically apply for an order of committal against that person. Yeah. And then that person will be summoned to court and has to explain why he or she has not been complying with that order. And there can be pretty serious and hefty sentences for that if they are unable to give a satisfactory explanation and if the court finds them guilty of contempt.
Okay, so then I just want to ask one more question on this before we move to another scenario, which will kind of loop back to similar themes, but kind of parallel to what I was asking Vivian about mediation and about having to kind of meet this person face to face. In the harassment court process, this is a question from the audience is, are there options for like online court meetings or things like that to avoid having to meet in person?
Yes, definitely. The couple of mediations I've had so far has been online, actually, and that's been quite helpful as well, because sometimes you don't want to see your perpetrator face to face. So certainly there is, yes.
Okay, and then Kenneth, does that apply to the protection from harassment court?
Yeah, it's the same. It may be a convenience. It may be a situation born of convenience, unfortunately, from the COVID pandemic. But a lot of court hearings nowadays and mediations conducted by the State Courts Center for Dispute Resolution, the SCCA, and the harassment court, of course. A lot of them are actually all conducted over Zoom. So, I think that would make it slightly easier as well for victims to participate meaningfully in any mediation with the perpetrators, as opposed to having to see them face to face, of course, like Vivian mentioned.
I see. Okay, well, thank you both for the discussion on this particular scenario. I think now we'll go to a second one that gets a little bit more complex because, the perpetrator is not clearly known. So one day out of the blue, Jamie, a working adult, wakes up to a slew of missed calls and lewd messages from strangers, as well as hundreds of new follower requests on their social media accounts. Jamie finds out that their social media photos have been posted to several blogs and forums that are dedicated to sexualized content. These photos were accompanied by Jamie's social media handles and phone number. So let's explore what Jamie can do in this situation. I think I would imagine that if I was in this position, one of my first thoughts would be, okay, this is something to make a police report about. But I think, a cause for doubt would be not having any idea about who the perpetrator is. So maybe I will start off with Vivian again. Do you think it's still a good idea to make a police report in this case?
Definitely, Holly. Jamie should lodge a police report as soon as possible. And these days she can do it online or just head to her nearest police post. And the process will be very similar to what we discussed earlier.
Okay, good to know. So then, what about a similar question for Kenneth regarding protection orders in this case? Would the fact that Jamie doesn't know who this perpetrator is make that more difficult, not possible, still possible?
Okay, so in this particular scenario, I think before we move to the separate question of whether Jamie not knowing who the perpetrator is, whether that would affect their ability to get a PO. I think just generally speaking first, in terms of this situation, the publication of Jamie's social media handles and phone number as well is likely to fall under doxxing, which is actually specifically dealt with under the POHA Act provisions. It's not called doxxing there though. But there it's called, or it's mentioned as the phrase identity information. So, I mean, like you asked, Holly, if Jamie has that person's username or social media account, or any other unique identifier, she may actually be able to get a PO, a protection order. So it's the fact that Jamie may not know who the perpetrator is, that doesn't weigh into the court's consideration actually, apart from the substantive part of the application. The court will be more concerned with whether service would be possible first. And as I previously mentioned, service is possible if you have the person's username or social media account, or yeah, basically their handles. Yeah. So the courts also have the power to, they do have the power to grant protection orders against a respondent whose name is unknown or anonymous. And by name, I mean the person's real name. I don't mean social media handles. So for example, let's say we have a situation where the respondent has been harassing the victim on Instagram or through Facebook direct message, but the perpetrator's Instagram account or Facebook account does not have their real name or their identity or photos which would enable you to identify who they are in real life. In this situation, it's tricky. It is tricky, but the victim can still apply for and can obtain a protection order for those acts of harassment. So basically, the applicant would have to provide the respondent's social media handle or username or any other what the POHA Act calls unique identifier. That has to be provided to the court, but the application definitely still can be heard and can be decided on that.
Okay, yeah, very good to know. So then we already talked about how you would serve it, because you already mentioned in our last scenario, that this can be just served directly on social media or by email, whatever kind of identifier you have. But then I was also thinking about what if, Jamie's goal is not necessarily, about holding, say, this person accountable or anything, but is more just trying to get their photos taken off of this site. But I think with a lot of these, you don't want to contact these sites directly because they're clearly pretty malicious. So is there any way that the law, particularly protection orders, can be useful there? Oh, sorry. Okay. I think Kenneth's computer has crashed, so he will be back in a few moments. One moment, let's see. I think I can actually go ahead and share a bit from my perspective on this, not about exactly how a PO can help. Hopefully Kenneth will be back in a moment to share that. But as kind of a complement to these legal routes, there is always the option of reporting to the site and sort of engaging directly. And if this scenario were taking place, say, on like Twitter or Instagram or something more mainstream, then that's definitely a good course of action to start with, because then rather than go through the legal process, you're just trusting essentially these sites that have like community guidelines and safety policies to take down the content for you. But if these are on like independent blogs, then Jamie would need to take more steps to keep themselves safe, because there are instances where trying to message a site like this to get your photos taken down results in further harassment. So on Solid Ground, for instance, where we have a guide for these kind of experiences, some of the things that we recommend is like using a throwaway email. So like an email you just make for this purpose that's not linked to your identity, and kind of as much privacy as you can get from, say, private browsing or using a VPN if possible. But then in general, if the site really looks actively malicious, like not just lewd, but like clearly dedicated to non-consensual content and things like that, then really the advice from most kind of groups around the world that work on this is to avoid contacting them at all, because you're basically not going to get anywhere. So this is potentially where legal remedies come in. And so maybe here I'll ask Vivian a bit about how things like a protection order or maybe any other, whether criminal or civil routes, can be useful in dealing with yeah, not just getting a judgment or decision, but getting this content taken down?
Good question. I always, in this type of scenario, I think self-help is very important. And I've looked into your website, and there are other websites now available. So to advise you on what to do. It is a very tricky situation because, I've been with clients and we've gone into like Instagram posts, we've gone into the post and we've gone to self-report. But there's a whole process there, as you know, why are you reporting this? You're reporting this comment because it's a bullying, it's harassment or whatever. And then they are a bit slow to take steps because they have their own internal processes. So it really depends on the seriousness. And of course, you, and at the first port of calls, you need to protect yourself. And then you need to get support. Support is very important because, you're being victimized, you feel depressed, you need get a friend. If you're under 21, get a trusted adult and head to the police station. If anything, at least they can, if they manage to contact the person, because the police do have powers to investigate. They manage to contact the person, find the person, they make that one call, which is enough for you, right? That one call. And most of us, most normal human beings, when you get a call from the police, you already know that it's not a good thing. So it will scare the living daylights, as I said, out of them. But you need to identify the person first. So that's always the trouble. So you can go to the police as well to get them to try and help you identify the person. So self-help in that sense. And then, file your magistrate's complaint or file for your POHA. Do it quickly. These are all online forms, and all the good advice that I've seen on your website and other websites about document collection will really assist and aid in the case. And tell your friends as well. Tell them, this is happening to me, so they are aware not to believe the posts. Yeah. And they can sort of ring fence you and protect you and says, look, so and so is now being a victim. We've got to help her out, and they come together in the community. Yeah.
So actually, let's continue on that a little bit, because you brought up a few different things, which kind of actually recaps a few of the different things we've been talking about. And additionally, so I saw a question from the audience that was saying, how does one decide whether to file a police report or a magistrate's complaint or make an application under POHA? Are these mutually exclusive? Can they be done together? So I think we've already talked about how they are not mutually exclusive. But I think in this case, if we think through this particular scenario, Vivienne, you were kind of bringing up, a few different things, how maybe a magistrate's complaint could be helpful, how the police could be helpful, but maybe we can just explain a bit more about the interconnections between these different things. If, say, you maybe start down the protection order avenue first, is it completely separate that you try to report to the police? Or just are there any connections between these? Will the courts help you strategize in coordinating these things, or is it multiple processes?
Perhaps I can just share a bit more about the POHA angle before Vivienne may want to add something about the magistrate's complaints. So I think first, it's very important to emphasize that these are not mutually exclusive avenues or options for you. In terms of POHA applications, for example, one question or one area which the court may be interested in or to know about, or which should be relevant when you're making your POHA application, is whether you have actually filed a police report about those acts or that harassing conduct. So it's definitely not mutually exclusive angles. I think I would say that if you believe your physical, if you have good reason to believe your physical safety is in danger, you should definitely file a police report immediately. And then, of course, you can decide to go on and take out your applications for a protection order, or, like I mentioned, an urgent EPO that functions as a temporary or interim protection order. But the long and short of it is that they are definitely not mutually exclusive. Yeah.
Yeah, Vivienne.
I would agree they're not mutually. You can do things together. So I've had often clients who file a police report first, port of call, and then decide whether they want to go to POHA or magistrate's complaint or other means, even because they can go straight to mediation if they know the person. And of course, if the act is very malicious, usually from experience, the perpetrator is within a known group, and it's just a question of time for you to be able to locate them. But I think I've come across one case, not my case, someone's mentioned to me that they filed a police report and then they wanted to protect themselves. So they redacted the police report, all the relevant pertinent details, and they posted it online to show to the world on their online presence that they are being bullied and something is happening. So because that's self-help to me. And then they went to file a magistrate's complaint. And in that situation, what happened was the police were already decided to investigate the matter. So the magistrate did not have to direct because the police felt that the matter was serious enough to just investigate straight away. But the client was just protecting himself, filing a police report, making a magistrate's complaint, just in case the police decide not to investigate. So the magistrates in that situation, the magistrate won't have, well, it's not necessary for the magistrates to ask the police to investigate because the police are investigating and the police have indicated that they will probably press charges to the magistrates. So in that sense, the magistrate's complaint falls away. But there's nothing wrong with suggesting or asking for a criminal mediation at the same time. So there are various tools available to you.
I see. But for instance, in this scenario, if the perpetrator is not known, or as in all you have is like a social media handle, then the process of the magistrate's complaint becomes trickier, right? If you don't have the person's identity to serve it to. It
takes a longer time. It's just like the POHA case, similar. The courts have certain powers. Just give them some lead, then they can do some investigations. And I mean, the police have certain powers as well. So like in my example, in my case, actually, we only had the person's name. We didn't know his address and anything, but the police, once you file a magistrate's complaint, the court does the service that Kenneth was talking about, the service of the documents to notify you that a complaint has been made against you. So that is a very important step in any proceedings, a notification to the perpetrator, as it were. So the courts actually do all that for you.
So then, I want to continue to clarify this just because I think in terms of online harassment specifically, there are so many cases where, you really maybe have very little leads. Maybe the site is hosted outside of Singapore. Someone has a generic username or continues to make different accounts. We have a question from the audience asking, so if you get a PO against an anonymous person, then can the police go into, say, social media platforms to investigate, to try to identify this person? So I think what I want to kind of may add on to this question to clarify specifically is just sort of the process of how, if say you've made a police report and they've said that they won't investigate for whatever reason, and so you've decided to go down the route of a protection order and it's been filed against an anonymous person. Is there any way then to, I don't know, route back to saying we need the police to investigate this, or not so much? And I don't know which of you is better equipped to speak on this, so whoever.
I think that this is a very tricky situation. It's not straightforward, for sure. I think that the police, if you do already have a protection order in place, they may be more prepared to help you take this on and to look into it and to prevent any breaches of that order of court and to investigate any breaches, of course. But I think it's a very tricky situation for sure. As we know, online harm and online harassment, it's a very it's a very real problem, but it's also a very amorphous problem. What I can say is that in practical, I mean, looking at it from a practical standpoint, if you have a protection order against that particular, against a person holding that particular social media account, this does not mean for sure that you are going to be able to enforce it. It doesn't mean that, oh, it's going to be 100% chance that you can stop the acts at source and definitely stop the acts. But
no,
it's okay. But I think he was going to say that you have a very, very good chance, though. You know, you have a very, very good chance because, you know, if you go to the police with a protection order, they will look into your matter seriously because the court has granted you some protection and orders. You know, I mean, if the person keeps doing it, then of course Kenneth talked about contempt proceedings in that situation. And you know, the worst case scenario for contempt proceedings would be going to jail, right? And of course, the fact of repeated behavior, it's not going to bode well for the perpetrator, and it would definitely he would very, very likely be charged for criminal offense in that situation.
Interesting.
But,
I see. So that's So that's kind of the route that you end up back at jail, even if you started on the civil path. That's kind of the last resort is still something along those lines. I see it.
But Kenneth is right. This area, I mean, really locating the person is finding out, you know, with all the different internet addresses all over the world, that's a tough point. But the police have powers. And we find that increasingly as we become more aware about these type of crimes, or this type of acts rather, some of which are crimes, you find that they are actually very helpful and they will look into the matter very, very seriously.
Okay, so then I want to add an interesting kind of pair of questions from our audience that's sort of more from the perspective of someone who is the respondent, in this case, the one whom a protection order is being brought against. So yeah, let me see. So there are two questions that I'm referring to. So one, someone asks, someone has applied for a protection order against me on the basis of false accusations. What can I do to defend myself? And then another question is specifically about, in the process, when is the perpetrator given notice of these proceedings and a chance to defend themselves? So kind of at what point that happens.
Okay, I'll answer the second question first. You will be given notice quite quickly after the complaint is made. And once the papers are filed, if they feel that this is something they need to investigate, it's worthy of investigation, then the next step, quite quickly, you will be served with the papers. Yeah. So I hope I've answered that question. They're not going to wait to serve the papers on you. They're going to definitely serve the papers on you because you have a right to be heard, right? It does not mean that just because you know, you've been called up and you've been served the papers that you're guilty, right? Because in law, we always say guilty until proven, innocent until proven guilty. Yeah. So you'll be served the papers quite quickly, provided they can be served on you. What was the first question again?
So someone was saying, yeah, the false accusations, you know, obviously not agreed with by the respondent. How can they defend themselves?
Okay. So likewise, I think it's the same thing if you're bringing a claim, get all the evidence that you need to defend yourself, right? And if you really, it's a false accusation, gather all the evidence and state so quickly, you know, or see a lawyer to get, and you know, if you need to see a lawyer, if you need advice to defend yourself, it might be a situation of mistaken identity, hopefully. So arm yourself with ammunition, with documents. It says it wasn't me, I didn't do that. I mean, there was a misunderstanding, apologize. And I mean, it depends on whether it was a misunderstanding type situation or wrong person type situation, right? But yeah, go ahead and defend yourself for sure.
I see. Another question about this I'm not sure if you'll have more to add, because it's kind of also addressing this difficulty of identifying people online.
Mhm.
So someone asks if the harassment is on social media using fake accounts, but I'm certain about who the perpetrator is. So maybe, I don't know, they're making references that you know, who knows this information or who has this motive. What can I do to help the police to gather evidence to charge the suspect?
I think you can, you can indicate to the police, because they will ask you anyway, right? They will ask you. I have experience with it. They will say, who do you think did this? And you can indicate, and they will then investigate to see whether it was that person. You need to give them a lead, as it were. You watch these leads. Give them some form of leads. And again, I want to emphasize that the police do have powers to speak directly to the social media platforms and ask them for information, right? Especially if it's within Singapore itself, if they have a presence here, right? They have some cooperation agreements, but I mean, it's quite difficult. Of course, if it's to a platform you don't know, then it is tough. This is a problem. It's a worldwide problem. But yeah, by all means, gather your evidence. If you present, I've read some stories of some of these victims, and their resilience is amazing. They've gotten friends and people together, and they've gotten the evidence. They put everything, so it's very easy. It's easier at the end of the day, for the police.
To clear up, I see. Yeah, so then I actually wanted to add kind of a clarification, as you were mentioning about, that sometimes the sites are difficult, whether they're in or outside of Singapore makes a difference. So something that we kind of clarified in the process of researching this, and also speaking to Kenneth about the intricacies of POHA, is about how, getting a PO is useful, because then you're dealing essentially with one individual and asking them to take this offending content down. Whereas the difficulty of say if a Singaporean has posted content to a non-Singapore site, it is going to be legally, more straightforward to try for something like a protection order, or if you can, ascertain their identity, something else, to address this individual, rather than going down the route of trying to get this site to comply and potentially take it down. So that's something that I clarify, because often victims, especially in cases with images or intimate images, might turn to things like copyright law and things like that, which also try to deal with the site essentially to get them to remove offending content. But in this case, this is a way in which a protection order can be useful. Anything to add to that, Kenneth, just to check my summary of how that applies to content specifically?
Sure. Yeah. No, I think you're absolutely right. Yeah, I think you've covered basically what the position is. I think I would just emphasize and stress also, and I think Vivienne, she has also mentioned the importance of self-help remedies. That, I mean, in these kinds of tricky situations, you really just you should exercise all the self-help remedies that you can to try and get this stopped. So sometimes all these platforms, like you mentioned, especially if they're outside Singapore, in terms of the law, it's going to be it will be a bit tricky to enforce any orders against these platforms. But I think, on the other hand, some of these platforms are also generally quite willing to play ball if you make a report on the platform itself. I mean, it's not necessary for you to have to serve something that has an effect in a court of law against that platform for them to comply with the request also. I think there was a pretty prominent case in Singapore of Doxxing, where basically it happened on Tumblr, and it happened to a Singaporean victim. I think she was in her early 20s when it happened. But basically, she actually managed to get Tumblr to take it down, if I recall, because her friend was a Tumblr admin who managed to get the email address of the Tumblr account who was posting those harassing images. So, I mean, this is just an example of how, of course, I mean, it definitely helped that her friend was a Tumblr admin at the time, and this will be quite rare, I would say. It would be more uncommon than not. But I think my point is just that try not to be disheartened if one avenue, just because there are difficulties with proceeding in one avenue or not. I think the most important thing is to try and make sure that you are kept safe, and as far as possible, you are able to protect yourselves, either in the POHA angle or the magistrate's complaint angle. And of course, in parallel to that, trying to exercise your self-help remedies and making a police report as well. And of course, I think it is, of course, difficult to try and can be very daunting to take these things on your own. So like Vivienne mentioned, keep your close friends or your family, if you're comfortable with it, in the loop, and they can actually help you to take some of these actions as well to protect yourself. And reach out.
Yeah, that's certainly great advice, especially as online actions can be so large in number. For instance, like a large number of messages or calls or maybe posts to different places that, I just want to agree that, if you can, choose someone you trust, even if maybe you feel embarrassed or whatever, really kind of dividing the work of, say, going to each of these websites and taking screenshots, things that can really be very time consuming, can be very helpful. Just with not making the process distressing kind of all over again. So I also want to ask, you were talking about self-help routes, and earlier, Vivienne, you mentioned someone posting their redacted police report online to let people know that they were being bullied. But I also just want to ask, is there any risk of this kind of backfiring on someone, say by then the person that they're claiming is bullying them saying, no, you're bullying me, you posted this online, and how could someone keep that from happening?
Okay, I think I need to be clear here. When I said redacted police report, I don't mean name names. I mean to show the seriousness. You obviously have to redact the person's name that you're accusing. And the police investigation number, right? The paper number. So the idea here for that person was to show that something is happening to me and I've taken police action. So that, and say, oh, you've put a police report, what happened? This is somebody is cyberbullying me or doxing me or whatever it may be, or harassing me or stalking me. Just that. So we're talking about self-help here. I wouldn't advocate anything more than that, because we shouldn't interfere with the police investigations. It's more personal protection for yourself, in the sense that friends, if you happen to see something, there's this person out there calling me as a bad word or something, and putting all my pictures, doctoring my images, creating memes. So I've done something about it. I've made a police report, so people will know, rather than people calling you and or other people believing such images, because it's a very insidious thing. This, especially when it comes to younger people. It's really, it can be really bad. You could be going out. We've had cases where a boy called a girl, and then the girl told her boyfriend that this guy's interested in me, and then the boyfriend decides to dox the person who called the girlfriend because he was busy, for example, in a national service. So he had no time for his girlfriend. And it's actually his girlfriend who's going around looking for attention. And then the boyfriend who's in national service finds out and decides to say things about this boy. He's a pedophile. He goes out with, he's attacking girls who are 12 and 11. And then the whole community was like, watch out for this person. And then the poor boy, right? One call. So these things are actually quite prevalent in this day and age. Or it could be, for example, we've seen just, one act done by a young adult, and, the person knows the perpetrator knows about this act and he's just saying, you are this person, you're this person, you're this person, you're this person. I'm going to tell everyone on social media that you did this, even though it was done 6 months ago. I'm going to tell everybody that you've done it, and then starts harassing the person through WhatsApp and other platforms. So it's actually quite insidious. And because of this, we where will the police step in? There's so many things that the police have to do at the same time. So they need to look at whether these offenses are very serious and the harm caused, which we looked at earlier. And the police will then decide whether to investigate. But you need to do something to help yourself first. And having a trusted friend or adult would help.
I see. So then another question I want to add, just to make sure that for everyone here, we've given sort of a holistic picture of this, is I think a lot of people have questions that are variations on what counts as harassment, things like that. And I think for everyone, I think from the information that both of you have shared, it's clear that there's a lot of factors that go into deciding, should I report to the police or things like that. But I thought maybe, Kenneth, you could give just a brief summary of sort of, what is harassment? And for instance, with the examples we've shared, what if, for instance, with Jamie, their contact information wasn't shared? Is just, say, sharing photos of someone constitute harassment, or how is this definition formed?
Sure. Yeah, I think it's a great and it's a very important question. The long and short of it is that there is no rigid or one-size-fits-all definition of harassment for the purposes of protection applications for protection orders. The court will always look at the facts of the case and see if the conduct has caused or will cause harassment or alarm or distress to the applicant. That's of course if the order is not granted. So basically, I think it may not be helpful to think of it in terms of black and white, what is and what is not harassment, but it all depends on the facts. And what I can say is that if we look at conduct, harassing conduct on a spectrum, so I think on one end of the spectrum, towards the more serious end, of course, would be if there's physical stalking or if there's clear threats of violence that's going to imminently be taken out against you. Or if you've mentioned, if your images have been shared, particularly if they're intimate images, that would quite clearly fall under harassment, that the court will say, okay, look, I'm pretty convinced that I need to protect this victim with a protection order. So and doxing also, of course. Doxing is actually one of the types of harassment that the legislation, the POHA statutes, it actually went to the trouble of expressly providing for it and saying that, identity information of a person cannot be, it must be protected, and it should not be shared without their consent. So examples of identity information are your name, your social media handles, or your address, your physical address, of course, or your email address, or photos identifying you if they show your face, for example, or if someone posts saying that, oh, I know this person XYZ is from this school, you can find him or her at this address, and so on. All of that on the spectrum, it constitutes quite clear acts of harassment. Yeah.
Okay, yeah, that's very good to know these specific markers, even though of course it's still dependent on the particular facts.
Yeah. Sorry, sorry to interrupt, Holly, just to add on. Yeah, and it doesn't mean that just because identity information or doxing, so to speak, just even if that is not present in a particular case, that doesn't mean that there's no harassment. The court will always look at the facts of the application that is put before it to decide. And there's no clear one size fits all. So I think it basically, just because there's no doxing involved does not mean that there's no harassment. But if there is doxing, then it's quite clear that the purpose of the legislation was very clear in wanting to protect you from this.
Okay, while we're discussing these, there's an additional question from the audience that's quite specific, but I'll see if you guys have ideas on this, which is basically about if the person applying for the protection order has maybe submitted evidence that has been altered, for instance, showing a screenshot of messages, but certain messages were deleted and only showing kind of one side of the story, then what could the accused person do? So I don't know if you have particular thoughts on how this might play out in terms of the evidence specifically.
See, I think if you're referring to a case where an applicant redacts parts of the messages that they put before the court as evidence, for example, I mean, assuming that those redactions are clear, it's not something that, basically assuming that the court has noticed it, I think the judge would have asked, can I check what has been hidden from these messages, and do you have a reason for redacting them? So that's on the court side. As for the respondent side, not really the accused person, but the respondent for POHA applications at least. Assuming the respondent also has his or her own set of those messages, the respondent will actually have an opportunity to put the full set of the messages before the court as well. Because the court will want to hear from both sides of the story before it makes any final protection order. So there is actually an opportunity for that.
Yes, I agree with Kenneth. There's always an opportunity to be heard, and the court will want to hear both sides of the story, which is why I find criminal mediation, and any mediation for that matter, a really great tool, because oftentimes this is just a lot of misunderstanding and miscommunication. Unless the intent is malicious, then that's a different matter altogether.
So then, as we get closer to the end now, I want to bring up a few things that are particularly, to kind of help victims through this process. So first, for maybe both Vivienne and Kenneth to respond is, how do you both as lawyers try to make this process easier on people who are trying to bring cases or file for a protection order, to try to essentially cause, less trauma than they've already experienced? Maybe Kenneth, you can go first.
So I think one thing we always bear in mind is that these cases can be very sensitive. They can already be very distressing on the victims. So I try to assure applicants that any information we receive will be kept completely confidential. If we're asking for certain documents or more particulars, for example, it's only so that we can put forth an application that will get you the protection that you need from the court. But we definitely assure them that anything you share with us is completely confidential. And where we can do it, we will also actually try to do a lot of the groundwork on their behalf, such as the collection of evidence, because in terms of the court process, you want to put forth a case which accurately, of course, but also which effectively shows the urgency of the situation. And to do that, you will need a lot of, you may need quite a number of screenshots of the harassment that happened, the time frame in which it happened, whether you know who owns those social media accounts which are posting those things about you. Because sometimes you will need to do some sort of investigations or sleuthing on your part to sort of tie a particular social media account to a person. For instance, in my experience, there was a situation, I had a case where it was not immediately clear who a particular Facebook account belonged to, but when we cross-referenced that particular username across other platforms, we eventually found one instance where the person actually posted his real name for that account name, but on a completely different social media platform that was very obscure. So these are the sort of things that victims may not be able to have the presence of mind to execute, because I mean, you'll be telling them to sort of confront their perpetrator or the trauma immediately by having to go down all these routes. So we try to, the long and short of it is we try to do the groundwork on their behalf, because we understand how difficult it can be for a victim to have to source for and obtain all these kinds of information, you know, giving the possibly very traumatic experiences that they may have had.
Yeah, Kenneth is right. I mean, you know, they are usually already at that point of time very stressed, and they just can't, some of them can't get their thoughts together even. So sometimes as lawyers, we help them with the investigative work. Oftentimes I tell them to try really get a trusted friend to help them with that, because that would help reduce their legal costs. That's something actually that really can be done. But I hear, I mean, I know what Kenneth says when he says that they all stress and they can't do simple things for themselves until after a while. So what we do as lawyers is we help them understand the various options, processes which are there to help them. And I find that oftentimes I have to assure the clients quite a lot and share a lot of previous cases, spirit stories, and the likely outcomes. They are always very, very interested to know about previous cases and the likely outcomes. And also, I personally always tell them to go for to seek help from non-legal routes, like to go for counseling and really open up about the situation, you know, and to really strengthen themselves. Not easy situation.
Well, yeah, thank you both. And to kind of, you know, to kind of make this easier for people, yeah, maybe Kenneth, could you share a bit about how people can find legal support in Singapore, maybe particularly, early stages, or if they're looking for pro bono support?
Yeah, sure, of course. So the Law Society Pro Bono Office actually provides free legal clinics for certain types of matters. And what happens at these clinics is that there will be volunteer lawyers present who will be able to give you a short one-on-one consultation in that session. And they are not allowed to represent you after that session is concluded. You cannot engage those particular lawyers, but what they can do is they will be able to give you some preliminary thoughts or from a lawyer's point of view on the legal actions possible in a particular situation. And they will be able to point you towards where they think you can seek further help at that point as well. And all of that is actually organized by the Law Society Pro Bono Services office. And I think that we will be dropping a link in the chat soon. And you can see the QR code that's flashing up on the screen share right now as well. The one on the left is for a more general list of resources. And then the one that I spoke about legal clinics, that is on the right side of your screen. So, well, you can also go to the Law Society Pro Bono Office's website to learn more about the legal clinics scheme. And yeah, I think the most important thing is to reach out.
Yes, yeah, they were explaining that, yeah, these clinics are a great place to basically get kind of a diagnostic look at, yeah, what your options are, what you can do next. And so, yeah, you can use that QR code. And then the other one on the left of the screen, yeah, has additional resources. So particularly linking to specific state courts websites that, or pages on their website that are useful, that have detailed information about magistrates' complaints and actions like this. And that also have resources from Solid Ground, which is a Singapore-specific site for resources that includes both kind of technical or self-help ones like reporting to platforms and keeping yourself safe, as well as, yeah, processes like filing for a protection order or making a police report. So then additionally, this other QR code will tell you about the different webinars that are also available for you to participate in for free. Or you can visit cdc.gov.sg/law awareness weeks to register for these. The next one will be Preparing for Golden Years, Get to Know Your Legal Instruments, Documents, and Processes. And that's happening on 19th October at 7 p.m. So after this webinar ends, a feedback form will be shown in your browser, which we appreciate if you can just take a couple of minutes to complete so that we can improve our webinars. So I want to thank Vivienne and Kenneth, so much for sharing your expertise with us. And with that, we'll come to a close. So thank you so much on behalf of Law Society Pro Bono Services for joining us on this Saturday morning, and have a great week ahead.
Thank you.
Thank you, everyone.